Dear students, subscribers and the viewers, welcome to the IAS Mentor. Today in this lecture we are going to see an important topic of the Indian Constitution, that is amendment to the Constitution of India. We already learned that the Constitution of India is an organic document. Now in fact one of the feature of the Constitution is a organic document, which means the Constitution is a living document. And how do we say that the Constitution is a living document? We say the Constitution is a living document because of the fact that the Constitution can go for a change, or it can be changed in the future, and that is how the Constituent Assembly has designed the Constitution of India. And that means the Constitution can be amended. And to that extent, the power to amend the Constitution has been given to the Parliament of India. So, who is the only authority who can make changes to the Constitution of India is the Parliament. And that particular power is given to the Parliament by virtue of Article 368 of the Constitution. And that is exactly what we are going to study in this particular lecture as to how the Constitution of India can be amended. What are the different types of amendment? What are the majorities that is required to amend the Constitution? What is the procedure that is to be followed in amending the Constitution? Can the Constitution be amended in total? That means can the Constitution can be completely changed by the Parliament based on the power that is given to the Parliament under Article 368? So in this lecture, we will try to answer all these questions. Okay, so that is exactly what is the objective of this particular lecture. This is lecture number 47 in the series Indian Polity. As I already stated, the larger objective of this particular series is to provide a comprehensive idea to the students with regard to the subject Indian Polity, and in the process we will also cover the LAXMIKANTH book. There is no doubt in that. And this series will be extremely useful for the students preparing for the UPSC examination as well as the other competitive examination. So with that, let us just get into the topic of what is called as the amendment to the Constitution. So before we understand all those things, let us try to understand all these questions. Before we understand as to the procedure as to how the Constitution can be amended. So the first question is, what is the need to amend the Constitution? Why do we have to amend the Constitution? And in fact, the vision of the members of the Constituent Assembly is such, they knew that any Constitution cannot be a static document. And if the Constitution is a static document, then probably that Constitution will not change or cannot adopt as per the changing circumstances, as per the changing social, economic and political requirements of the community of the people. So any Constitution would be successful if it is able to change and accustom itself to the changing political, economic and the social circumstances. And for which the Constituent Assembly members thought, okay, we will draft the Constitution, and today we are drafting the Constitution based on our historical understanding and also our understanding of the society in the present circumstances based on what is expected out of a Constitution. But however, in the future, the needs of the people might change, the values of the people might change. So we cannot carry forward this Constitution without any changes when all those things changes in the future. So therefore, as and when there is a need for a change, probably there should be some way to make changes to the Constitution, and for which the Constitution itself should say as to how to amend the Constitution. So thinking about all those things, the members of the Constituent Assembly, as I already said, while they were drafting the Constitution, they brought in Article 368 of the Constitution, which talks about as to how the Constitution can be amended. So somebody has to be given the authority to amend the Constitution. And to whom this Article 368 is giving the authority? Article 368 is giving the power to the Parliament of India. So if at all a question comes, who is authority to amend the Constitution of India? The only authority who has the power to amend the Constitution is the Parliament of India. And Article 368 confers this exclusive power only upon the Parliament. But however, there are ways, procedure which is also mentioned in the Constitution as to how the Constitution of India can be amended, which we will subsequently discuss. So then the next question is, now it is clear, yes, the Constitution can be amended and Parliament is authority to amend the Constitution. So is the amending the Constitution easy or is it difficult? That's the second question probably you might have to have. So it may vary from country to country as to how the Constitution can be amended. But however, in case of India, if you see, experts say that the constitution in India as to how it can be amended is a combination of what is called as rigidity as well as flexibility, or it is both flexible and rigid. That means there are some provisions in the constitution that can be easily amended, which means the process is relatively easier, the procedure is relatively easier. But whereas certain provisions in the constitution, it is extremely difficult to amend. So that means the procedure that is required to amend those provisions are extremely difficult. So that is why the experts say that the constitution of India is flexible as well as rigid in nature. And on the contrary, there are extremes also. Say for example, India, you can put it somewhere in the middle if you draw a line between flexibility and rigidity. But there are certain constitution which is in the extreme. One extreme is flexible constitution. Another extreme is the rigid constitution. So I am giving two countries, United Kingdom and United States of America. So between these two things, which is very flexible and which is very rigid. So if you know the answer, you can put it in the comment box. I have discussed about all those things in our previous lectures also. So out of these two constitutions, one is extremely flexible, another is extremely rigid. But whereas the Indian constitution is a combination of both rigidity as well as flexibility, which as already said, some of the provisions are very easy to make changes, but some of the provisions are very difficult to make changes. So that is why we say that it is a combination of both rigid as well as flexibility. Now we will also discuss with examples as to which provisions are difficult and which provisions are easy to make the changes, but I'll do it in the later part of the session as we will proceed. Now the second thing is, who has a power to amend the constitution? The next question is that we already seen it is the parliament is the only authority to amend the constitution. There is no other authority which can make changes to the constitution. That is, the state legislatures or any of the other authorities has no power. It is the exclusive power of the parliament. Can the constitution be amended in total? So this is a very good question. That means this question is trying to assess our understanding. Okay, the members of the Constituent Assembly has given the power to the Parliament to make changes to the Constitution, or in other words, to amend the Constitution. Using this power, can the Parliament change the Constitution of India in total? Can it completely give a new shape to the Constitution of India? Is it possible for the Parliament to amend any provisions in the Constitution? In fact, there was no clear answer for this particular question, because the constitution does not explicitly say anything in this particular regard, if you see the original constitution and even today also. So this question was there, and then finally we know that if any question that arises out of the interpretation of the constitution, who is the final interpreter of the Constitution of India? It is the Supreme Court of India. So this question was taken up by the Supreme Court of India in number of cases, starting 1950. And it went till 1973, almost for, I would say, a little more than 2 decades. This question was analyzed by the Supreme Court of India, and they had differing opinions in different cases. But ultimately, the Supreme Court came out with an answer for this particular question in a case which is called as the Keshavananda Bharati case, which is a very historic case in the history of India, which I'll discuss when I take up the doctrine of basic structure. Though probably in the next lecture, I'll start the doctrine of basic structure, where I'm going to discuss about this. Now, in the Keshavananda Bharati case in 1973, the Supreme Court has answered this particular question. Can the constitution be amended in total? The Supreme Court said no. The constitution cannot be amended in total. The parliament do have the power to amend the constitution, but it cannot amend every single provisions of the constitution. Or in other words, to put it in a very simple way, the Supreme Court said in the Keshavananda Bharati case, while the parliament can amend any provisions of the constitution, excluding those provisions which would be considered to be what is called as basic structure. So once some of the provisions of the constitution is considered to be basic structure, they cannot be amended by the parliament. Except for those provisions which is not a basic structure, all those things can be amended. So that is for the parliament to amend. But whatever is declared to be part of basic structure cannot be amended. And if you amend the basic structure, then we will declare the constitutional amendment to be invalid or illegal. This is what the opinion that was given by the Supreme Court in the Keshavananda Bharati case. But however, who would decide as to what constitutes a basic structure? It is the Supreme Court of India who can decide as to what constitutes the basic structure. So once something is declared to be part of basic structure, then those provisions cannot be amended. For example, The word democracy in the preamble has been declared to be part of basic structure. The word secular has been declared to be part of basic structure. And similarly, so on and so forth, a number of provisions in the Indian constitution has been declared to be part of basic structure. So that means once something has been declared to be part of basic structure, so they cannot be amended and they cannot be taken out of the constitution. And if the parliament tries to do that, then the Supreme Court of India can declare that amendment to be unconstitutional. So that means if you have to ask and understand this particular question, can the parliament amend the constitution in total? They cannot amend the constitution in total. They can amend everything in the constitution except those things which are declared to be part of what is called as the basic structure. So that is the basic understanding you should have. Is it clear to all of you? But ultimately, who will decide as to what is basic structure? It is the authority of the Supreme Court. So this is what the Supreme Court has told in the Keshavananda Bharati case, which I will discuss in detail later. Okay, so Keshavananda Bharati case 1973. So this much information is right now sufficient, but I'll discuss about this case in detail when I take up the doctrine of basic structure. One last question that you have to understand is, what are the ways by which the constitution can be amended? I said that the Indian constitution is both rigid as well as flexible. That is why it becomes relevant for this particular question. What are the ways by which the constitution of India can be amended? There are certain provisions in the constitution which can be easily amended, but there are certain provisions in the constitution which is very difficult to amend. That's why I said it's a combination of both rigidity as well as flexibility. So if you put overall all those things, there are some provisions in the constitution which can be amended by what is called as a simple procedure or a simple majority. There are certain provisions in the constitution which requires a special majority to amend it. That means the process is different in different things. There are certain provisions in the constitution which requires a special majority in the parliament, not necessarily just the special majority in the parliament, plus it requires ratification by the state legislature as well. Ratification by the state legislature. So these are the different ways as to how the constitution can be amended. So try to understand this. So when you ask me as to how the constitution can be amended, so there are different ways as to how the constitution can be amended. One, some provisions can be amended by what is called as a simple majority in the parliament, which I'll discuss. We already seen as to what these majorities are, but anyways, I'll try to give a fair idea in this particular lecture also. So certain provisions can be amended by simple majority in the parliament, but most of the provisions in the constitution is amended by what is called as the special majority in the parliament, which is a difficult process. And even more difficult process is, it requires not only the special majority in the parliament, but it also requires ratification by not less than half of the state legislatures in India. So that's an extremely difficult process of amending the constitution. So these are the three ways by which the constitution can be amended, but what you will have to understand exactly is, now in our previous lectures I have said that the constitution of India has been amended 106 times. Starting 1950, after the commencement of the constitution, the first constitutional amendment happened in 1951. And the latest constitutional amendment was ratified by the president in 2024. So in these years, that is between 1950 to 2024, how many amendments have happened to the constitution of India is 106 constitutional amendments. So this is the latest amendment, that is the 106th constitutional amendment. That means whenever an amendment happened to the constitution, it is numbered. And it is numbered as first, second, third, fourth, fifth, sixth, and so on and so forth. The latest amendment is the 106th constitutional amendment. Now this numbering system to the amendment that is happening in the constitution is only done for those amendments which is done under article 368 of the constitution. So this is the basic understanding you should have. So when I say that the constitution can be amended by different ways, I said the constitution, so this is the very crux of the understanding you should have. Please have a focused attention. So we have discussed that the constitution can be amended in number of ways. One is by simple majority, and other is by special majority plus ratification by half of the state legislature. Now these are the three ways you can make changes to the constitution. But if you classify these three amendments to the constitution, they can be classified as amendment outside the scope of Article 368 and amendment within the scope of Article 368. So if you say Article 368, there are two ways of amending the Constitution. What is the way by which you can amend the Constitution under Article 368? One is the special majority. I'll put it like this, special majority. And the other is special majority plus ratification by states. These are the two ways, ratification by states. So these are the two ways by which the Constitution can be amended under Article 368. But the Constitution can be amended outside Article 368. Outside Article 368, which requires only what is called as simple majority. So if it is outside Article 368, which requires just the simple majority. So both the things are the way by which the Constitution can be amended. So if you see as to how the Constitution can be amended, it is outside Article 368 and within Article 368. And outside Article 368, if any amendment is happening to the Constitution, that can happen by a simple majority. Within Article 368, if certain provisions in the Constitution are to be amended, they can be done by two ways: special majority in certain cases, special majority plus ratification by half of the state legislature in certain cases. But however, the numbering system that you are following today, that is right from First Amendment to the 106th Constitutional Amendment Act, all these amendments have happened under Article 368. So what do we actually call as amendment and what do we actually record by the numbering system is only those amendments which is happening under Article 368. We are not concerned much about the amendment that happens outside Article 368, which can happen by a simple act of Parliament. So what are those provisions in the Constitution that can be amended outside Article 368? There are few exceptions which is given in the Constitution itself. It is not that randomly any provision can be amended outside Article 368. What can be done outside Article 368 and what has to be done within Article 368, it is all given in the Constitution itself. So it is not the whims and fancies of the Parliament. It has to be done as it is laid down in the Parliament. So we'll see examples for all those things. But however, normally when we use the word constitutional amendment, what do we refer? We refer to all those amendments that is done under Article 368. Under Article 368 till this point of time, 106 constitutional amendment has been done. Under Article 368, there can be two types, but whatever be the type under Article 368, they are all considered to be amendment under Article 368, and in total till this point of time, we have got what is called as 106 amendments under Article 368 of the Constitution. So with that, we will try to understand the procedure as to how it happens. I am trying to explain you the procedure under Article 368. Okay, so first let me try to explain you the procedure under Article 368 and then how the amendment outside Article 368. So come to the procedure under Article 368. So we know that to amend the Constitution, first a bill has to be introduced. So that's the first basic thing. First a bill has to be introduced. A bill is nothing but a proposal. And that proposal will become and it can give the effect, and accordingly you can make changes to the Constitution after the bill is passed and then given assent by the President. So the initial step is a constitutional amendment bill is to be introduced. A legislative proposal is to be introduced to make changes to the Constitution. So what is the procedure under Article 368? It is saying the first step is first a constitutional amendment bill has to be introduced. And now the question is where the constitutional amendment bill has to be introduced as per Article 368. It can be introduced either in the Lok Sabha or in the Rajya Sabha. So this is a very important thing. So it can be introduced either in the Lok Sabha or in the Rajya Sabha. So it can be introduced in either houses of the Parliament. There is no restriction as to where it can be introduced. It can be introduced by a member of Parliament in the Lok Sabha or by a member of Parliament in the Rajya Sabha also. So the Constitution does not say it has to be introduced in only one particular house. Because why I am making this point very clear? Because for certain type of bills, there are different types of bills apart from a constitutional amendment bill, which I will subsequently discuss. In fact, I have given a very fair idea, a brief idea about as to what are the different types of bills when I was discussing the key terms in the polity. So if you want, you can go there and refer to that, but otherwise I'll discuss at a later stage when I take up the chapter of Parliament. But for time being, you should have an understanding this constitutional amendment bill can be introduced either in the Lok Sabha or in the Rajya Sabha. But there are certain types of bills, say example a money bill, which can be introduced only in the Lok Sabha, not in the Rajya Sabha. So the first house where it can be introduced only is in the Lok Sabha. But there's no such restriction when it comes to what is called as a constitutional amendment bill. It can be introduced either in the Lok Sabha or in the Rajya Sabha. Okay, once it is introduced, then it will go through the other process. But before that, who can introduce this particular bill? This bill can be introduced by any member of parliament. This is very important. Any member of parliament. Only a member of parliament can introduce, but he can be any member of parliament. That means basically he can be a minister or he can be a private member. That does not make any distinction. Minister or a private member. It can be introduced either by a minister or a private member. So who is a minister? A minister is a member of parliament, but he is also appointed as a minister in the government, in the cabinet, or in the council of minister. He is one minister and he is also a member of parliament, and he is considered to be a minister. But among the members of parliament, not everyone gets appointed as a minister. Only very few members, even from the ruling party, get appointed as a minister. So apart from the ministers in the parliament, whoever is the other members of the parliament, they are all considered to be what is called as a private member. So sometimes students ask, is the private member only from the opposition party? No, the private member is either from the opposition party or from the ruling party. It does not matter. Okay. So whoever it is, so they all can introduce a bill. So a constitutional amendment bill can be introduced either by a minister or by a private member. And then what is the majority that is required in this particular case? So once the bill is introduced, so where it can be introduced? It can be introduced either by a minister or by a private member. Where it can be introduced? It can be introduced either in the Lok Sabha or in the Rajya Sabha. Suppose let us assume it is introduced in the Lok Sabha, and then once it is introduced in the Lok Sabha, it has to be passed with what is called a special majority. So what is a special majority? So special majority we have already discussed. I'll discuss about it. Okay, let us assume it has to be passed with what is called a special majority. Now once it is passed with a special majority, suppose let us assume special majority in the Lok Sabha. Once it is passed with special majority in the Lok Sabha, then it will be passed to the next house, that is the Rajya Sabha. In the Rajya Sabha also it has to be passed with what is called a special majority. And once it is passed by both the houses by special majority, then it goes to the president for the assent. And then the president has to give the assent to the bill. I'll just come back to this particular area. But the point that you have to remember is that it has to be passed in the special majority in the Lok Sabha. After passed by Lok Sabha, it has to go to Rajya Sabha. It has to be passed with special majority in the Rajya Sabha also. Then it will go for the president assent. Suppose if the bill is introduced in the Rajya Sabha, in the Rajya Sabha it has to be passed with special majority, then it will be sent on to the Lok Sabha, it has to be passed with special majority, then it will go for the president for his assent. This is the basic understanding you should have. But the question is, what if there is any disagreement between these two houses? That means one house is agreeing it and other houses are not agreeing it. So if there is any disagreement, is there a possibility of joint sitting? So joint sitting is a concept where the members of both the houses of the parliament are called upon to sit together and then decide the proposal together instead of deciding it separately. Is there a provision for joint sitting when it comes to a constitutional amendment bill? There is no provision for joint sitting. So no joint sitting in case of what is called as a constitutional amendment bill. Why? Because Article 368 of the Constitution makes it very clear that a constitutional amendment bill has to be separately passed in both the houses of the parliament by special majority. Now what is a special majority? I am going to explain that. It has to be passed with special majority separately in both the houses of the parliament. That is what the Constitution is making it very clear. So there is no possibility of what is called as a joint sitting. Now I said that the special majority in case of a constitutional amendment bill, that is one thing. But I said that in certain cases there is special majority plus ratification by half of the states. Now under Article 368 I said two types of majority. One is special majority and another thing is special majority plus ratification by half of the states. Now under what circumstances it is special majority and under what circumstances it is special majority plus ratification by half of the states. Now special majority is when you are amending the provisions of the Constitution but special majority plus ratification by half of the states is required when the constitutional amendment bill is trying to amend the federal provisions of the constitution. This is what is very important. When they are trying to amend what is called as a federal provisions of the constitution. What do you understand by federal provisions of the constitution? For example, if there is an amendment to the fundamental rights, say for example, recently the EWS reservation was brought in. Article 15 clause 6 and Article 16 clause 6 was inserted to provide what is called as EWS reservation. So for more details on EWS reservation, you can go and watch my lecture on EWS reservation. So the constitution was amended by the 103rd Constitutional Amendment Act. They inserted Article 15 clause 6 in Article 15, Article 16 clause 6 in Article 16 to enable what is called as EWS reservation. So this is an amendment to the fundamental right. So this can be done under Article 368, but this amendment which is done under Article 368 is not altering the power balance between the center and the state. So this provision which is inserted into the fundamental right is no way disturbing the equilibrium of power between the center and the states. The equilibrium remains the same, or the power balance remains the same. But there are certain provisions in the constitution. If an amendment or change is made to those provisions, it may disturb the equilibrium or it may affect the power balance between the center and the state. It may give more powers to the center, it may give less power to the center, it may give more power to the state, less power to the state, whatever it is going to alter the existing power balance. So that means you are disturbing the federal balance, you are disturbing the federal provisions in the constitution. So whenever any constitutional amendment bill is trying to alter this balance, then that provisions also need to be ratified by half of the state legislature once it is passed by both the houses of the parliament by special majority. That's a basic understanding you should have. That means in addition to being passed by special majority in both the houses, then it shall also be ratified by not less than half of the state legislature. So what are the areas which requires ratification by the state legislatures also? That is also given in the constitution. You can go to Article 368. Article 368 gives detail as to which amendment to the constitution requires ratification by half of the state legislature. Say for example, any amendment to Schedule 7 of the constitution. If you go to Schedule 7 of the constitution, Schedule 7 of the constitution talks about the union list, state list and the concurrent list. So if you have to make changes in any of these lists, bringing items from the state list to the concurrent list or from the concurrent list to the union list, whatever may be the change in the Schedule 7, it requires ratification by half of the state legislatures as well, apart from special majority in both the houses of the parliament, because you are trying to alter the power balance between the center and the state. So apart from that, lot of other provisions are also given in the constitution. Say for example, if the constitutional amendment bill is trying to alter the powers of the Supreme Court, if it is trying to alter the powers of the high courts, it is all disturbing what is called as a federal structure in the constitution. So in all these cases, it requires ratification by not less than half of the state legislature. If there is any changes in the taxing structure, what are the taxing powers of the center and the state? This also requires ratification by not less than half of the state legislature. And if there is any amendment that is to be done under Article 368 itself, it also requires ratification by half of the state legislature. So these are all some of the provisions that is given in Article 368 which requires ratification by half of the state legislature. Apart from all these provisions, the other provision does not require ratification by half of the state legislature because they do not alter the power balance between the center and the state. So to put it in a very simple way, under Article 368, two types of amendments are possible. Both require special majority, but in one case it is special majority plus ratification by not less than half of the state legislature. Under what circumstances it requires ratification by not less than half of the state legislature in addition to the special majority? If the constitutional amendment bill is trying to disturb the power balance between the center and the state. In other cases, it's a constitutional amendment which is not disturbing the power balance between the center and the state. So this is the basic understanding you should have. I'm sure that it is quite clear to all of you. Okay, I spoke about special majority is ratification by not less than half of the state legislature. That is special majority plus ratification by not less than half of the state legislature. That means once it is passed by Lok Sabha and Rajya Sabha with special majority, then it will be sent to all the state legislatures in India. Today there are 28 state legislatures as of today. And out of this, when I say not less than half of the state legislature, the state legislatures have to ratify that with what is called as simple majority. So they also have to accept to this particular proposal. And to with what majority they have to accept this proposal? They have to accept it with simple majority in their respective legislature. When I say not less than half of the state legislatures, out of 28 state legislatures in India, it has to be ratified by 14 state legislatures at least. If there is only legislative assembly in a particular state, it shall be approved only by the legislative assembly. If there is a legislative council in a particular state, it has to be approved by both legislative assembly as well as council. But overall, how many states have to agree to this? Overall, 14 states minimum today has to agree. So tomorrow, if there are, let us assume 30 states, if the states are increased, then not less than half of the state legislature would mean at least 15 state legislatures have to give an approval to this. So this is basically what you'll have to understand. So the process is, in case of a constitutional amendment which is not disturbing the power balance, which is nowhere related to the federal provisions, then it has to be passed with special majority in both the houses, that is Lok Sabha, Rajya Sabha, or Rajya Sabha, Lok Sabha, then it goes to the president for his assent. But suppose if the bill is trying to amend the federal provisions in the constitution, then it has to then it has to be passed in both the houses, that is Lok Sabha, Rajya Sabha, or Rajya Sabha, Lok Sabha. Then it should also be sent to not less than half of the state legislatures. It will be sent to rather all the state legislatures, but at least approved by not less than half of the state legislature. When all these processes done, then it will go for the president assent. So president assent is a final step. It will go to what is called as a president assent, and then finally the president gives the assent. And when the president gives the assent, the bill becomes an act, and accordingly so and so changes as it was put in the constitutional amendment bill. After the assent is given by the president, it will make changes in the constitution, and that is considered to be what is called as a constitutional amendment act. So before the president gives the assent, it is called as a bill, and once the president gives the assent, it becomes an act, and once it becomes an act, it can make appropriate changes in the constitution to that extent what was approved by the president of India. So this is the basic understanding you should have. So now the question is, whenever a constitutional amendment bill is presented to the president, can the president exercise any of his veto powers? In fact, you will have to understand the president has no veto powers when it comes to what is called as the constitutional amendment bill. The only option in the hands of the president when it comes to a constitutional amendment bill is that he has to give the assent. It is mandatory for the president to give the assent, and it has been made mandatory by the 24th Constitutional Amendment Act in 1971. So please remember this. The president has no veto powers when it comes to what is called as a constitutional amendment bill. The only power or only option he can exercise is he has to compulsorily give the assent, and that is made mandatory under article, that is made mandatory by 24th Constitutional Amendment Act in 1971. Is that clear to all of you? So this is the entire process probably you'll have to keep in your mind. So now I just wanted to explain you some examples. I said 3 types of amendments that can happen. So for all the 3 types, I am having some examples. And then I'll also discuss as to what is a special majority for those students who are not aware of what is special majority, which I already discussed. I have made a separate video on different types of majorities. You can go and watch there for a detailed idea. But however, yes, for your understanding, I'll also explain as to what is special majority here. But before that, I said there are 3 types of amendments. One is amendment outside Article 368, which is done by a simple majority. And one such example is this Jammu and Kashmir Reorganization Act. Now, we know that the state of Jammu and Kashmir was split into 2 union territories. In fact, and they have been converted into 2 union territories. One is Jammu and Kashmir, the union territory of Jammu and Kashmir, another is the union territory of Ladakh. And this happened by passing this Jammu and Kashmir Reorganization Act 2019. So Jammu and Kashmir Reorganization Act 2019 was passed, and by that act what has happened? What is the outcome? The state of Jammu and Kashmir is created into 2 union territories. That is Union Territory of Jammu and Kashmir and Union Territory of what is called as Ladakh. Now when this act was passed, it was passed by simple majority. all that required to pass this particular act in the parliament was a simple majority. But now the question is, did this Jammu and Kashmir Reorganization Act, did it make any changes in the constitution? Yes, it did make change in the constitution. It made changes in the constitution in Schedule 1 and Schedule 4 of the constitution. And to what extent it has made changes in the Schedule 1 and Schedule 4 of the constitution? Because Schedule 1 contains the list of states and their territories, the list of union territories and its territories. So as and when Jammu and Kashmir was modified into 2 union territories, the state of Jammu and Kashmir, the 12th state of Jammu and Kashmir was converted into 2 union territories, that is Union Territory of Jammu and Kashmir and Union Territory of Ladakh. And to that extent, we'll have to make changes in the Schedule 1 of the constitution, because we'll have to add 2 new union territories under the topic Union Territory, and corresponding territories of the Union Territory should be mentioned. And similarly, from the state list, you will have to remove Jammu and Kashmir. So thereby, the 29 states have now become 28 states, and the union territories have become 8 today in our country with the addition of these 2 things. That means automatically there is a need for change in the Schedule 1 of the constitution, which is also part of the constitution. So this is also making changes to the constitution. And then there was a change to the Schedule 4 of the constitution also, because you need to allocate seats to the union territories. So the Union Territory of Jammu and Kashmir was allocated seats in the Rajya Sabha, and to that extent that should also be included in the Schedule 4 of the constitution. So when the Jammu and Kashmir Reorganization Act was passed, it has made changes to the Schedule 1 and Schedule 4 of the constitution. But all these things are done by a simple act of parliament, because by virtue of Article 4 in the constitution. Because Article 4 in the constitution says that if any law is made either under Article 2 or under Article 3. So basically this Jammu and Kashmir Reorganization Act was passed under Article 3 of the constitution. So for all these things, you can go back to my previous lectures on the union and its territories, where I have explained in detail about Article 1, 2, 3 and 4. But to cut the long story, so here if you understand, Article 3 is giving the power to the parliament to make internal reorganizations in our country. So any form of internal reorganization, because creating a state into 2 new union territories, it is not bringing any territory outside India into India. It's just making internal reorganization within the territory of India. So that can be done under Article 3. But in the process of making internal reorganization, if you make any changes to Schedule 1 and Schedule 4, not to any of the other provisions of the constitution, you are making changes only to Schedule 1 and Schedule 4, then it can be done by a simple act of parliament, because such an exception is given under Article 4 of the constitution. So Article 4 is saying that if any law is made under Article 3, and by that law you are making any internal reorganization, and therefore you are also making changes in Schedule 1 and Schedule 4 of the constitution, but not in any of the other provisions of the constitution, then although you are making changes to the constitution, it does not require a special majority. It can be done by a simple majority. So that's a basic understanding you should have. So this is an example of how the constitution can be amended outside Article 368. When I say outside Article 368, because it is done by a simple majority. If you have to do it under Article 368, it minimum requires special majority. But here it is a simple majority. So I hope you have an understanding of what is simple majority. Simple majority means the majority of the members present as well as voting. So that is what is simple majority. And for a detailed understanding, you can go back to my previous lecture on the majorities. Alright, so this is one example of how the constitution can be amended outside Article 368. One more example I can give you is the creation and abolition of legislative councils in the state. So if any state legislative council is to be created or it is to be abolished, that also makes changes in the constitution. In fact, it makes changes in Article 168 of the constitution, but that is also deemed to be an amendment outside Article 368. That means creation and abolition of legislative councils and therefore making changes in the constitution can happen by a simple act of parliament, because all these exceptions are given in the constitution itself. So if you ask me a question, where or which of the provisions in the constitution can be amended by a simple majority or a simple act of parliament? Only those things which is allowed in the constitution, if those exceptions are given in the constitution. All right. Apart from that, all other amendments are done under Article 368, and within Article 368, for certain amendments, you also require what is called as ratification by half of the states, especially when their amendment is trying to disturb the federal provisions in the constitution. So this is the basic understanding you should have. So for that also I am having a couple of examples. One is so these are both amendments under Article 368, but however, under Article 368, the first case requires only special majority. When I say special majority, means it has to be passed by special majority in both the houses of the parliament, then it goes to the president for his assent, and then the president gives the assent. There is no need to send it to the ratification of the state legislature. One such example is 103rd Constitutional Amendment Act, which was trying to bring what is called as EWS reservation. It made changes to the fundamental rights. It inserted Article 15 Clause 6 and Article 16 Clause 6. But by inserting Article 15 Clause 6 and Article 16 Clause 6, it is in no way going to disturb the power balance between the center and the state. So in this case, it requires just what is called as a special majority. But on the other hand, look into the 101st Constitutional Amendment Act, which brought in what is called as GST taxation system into our country. If you look into this GST taxation reforms, and to that extent, the 101 Constitutional Amendment Act, so this required special majority plus what is called as ratification by the states. It required both the things, ratification by not less than half of the states, ratification by states. Why? If you look into this 101st Constitutional Amendment Act, it was trying to vary the taxation structure in our country. It took away some of the taxing powers of the state, it took away some of the taxing powers of the union, and it allowed both of them to tax it. So for example, it took away the taxing powers of the center in the form of what is called as customs tax or excise duty. So these powers of the center was taken, and similarly for the states, the taxing powers like value added tax, the luxury tax which belonged to the states was taken away. And instead of that, they combined all these taxing powers and they made it what is called as goods and services taxes, where the center can also impose the central GST, where the states can impose what is called as state GST. That means you are trying to disturb the existing equilibrium. Something was the taxing power of the center, something was the taxing powers of the state. So that was the existing equilibrium. But instead of that, now you are bringing some GST tax where you are combining the taxing powers of center and the state. So in a way, it is beneficial or not beneficial. I'm not getting into that particular area. But you are trying to disturb the existing equilibrium by this constitutional amendment. So therefore, it also requires ratification by not less than half of the state legislature. In fact, not less than half of the state legislatures have ratified this, and then subsequently it was sent to the president for his assent, and therefore it became a constitutional amendment. So I have given examples for all the three types of amendments. But however, remember, when we talk of a constitutional amendment, generally it means amendment under Article 368. The numbers that we follow up to 106th Constitutional Amendment Act, all these amendments have been done under Article 368 of the Constitution. Whether something is ratified by the state, something may not be ratified by the state, that is not a problem. But amendment means usually under Article 368 of the Constitution. We are not concerned much about amendment that happens outside Article 368 of the Constitution by what is called as simple majority. Now for your understanding, let me also quickly explain what is special majority. Now special majority under Article 368 means it has to satisfy two conditions. So what are the conditions that it has to satisfy? So first of all, it has to satisfy the condition of not less than 2/3 members present and voting. 2/3 of the members present and voting. This is what is very important. Present and voting. So what is this not less than 2/3 of the members present and voting? That means when a constitutional amendment bill is put to vote, that proposal has to be satisfied or it has to be approved by not less than 2/3 of the members present and voting. Suppose let us assume there are 450 members. 450 members who are present and voting. This is what is very important. Say for example, even if there are 500 members, but out of these 500 members, if 50 members are not voting, they may present in the house, but they may not be voting. So that should not be taken into account. So out of this 500 members, although they are present, but how many are voting? Present as well as voting, it is only 450. So out of those present and voting, how many members have to support this particular proposal? The constitutional amendment bill should be not less than 2/3 of the members present and voting. That means in this case, minimum 300 members have to support this. So this is the number. minimum 300 members have to support this particular proposal. So if minimum 300 members support this particular proposal, then the first condition is satisfied. That is not less than 2/3 of the members present and voting. Then the second condition is, so this is the first condition. So in addition to the first condition, what is the second condition? The second condition is that this member, not less than 2/3 of the members present and voting, this 300 or more than 300, whatever it is, this should also satisfy the condition of what is called as absolute majority in the house. So how do you calculate what is absolute majority? Absolute majority is the majority of the total membership of the house. Say for example, in case of Lok Sabha, out of 543 members, if you have to calculate the absolute majority, it is 272. So absolute majority for Lok Sabha is 272. It is always going to remain constant. And the absolute majority for Rajya Sabha, out of 245 members, you can calculate. Out of 245, it would be 123. So that is the absolute majority. So in case of Lok Sabha, if I take the example of Lok Sabha in this case, so if 250 members are present and voting, the minimum 2/3 majority is 300. And this 300, whether it is more than 272, yes, it is more than 272. So that means both the conditions are satisfied in the Lok Sabha. And similarly, both the conditions should also be satisfied in the Rajya Sabha. When both the conditions are satisfied in both Lok Sabha as well as in the Rajya Sabha, then it is deemed the bill is passed by what is called as special majority. Then it goes for what is called as a president assent. But however, in case if the bill also requires ratification by the state legislature, so first it has to be passed with special majority in both the houses, that is in the Lok Sabha, then in the Rajya Sabha, or vice versa also, Rajya Sabha and Lok Sabha, depending upon where the bill is introduced. Then it cannot go to the president directly, it has to go to the state legislatures for their assent, where not less than half of the state legislatures have to give the assent by what is called as simple majority, give the approval or ratification by simple majority. When all these things are satisfied, then the bill will be sent to the president for his assent, where it is mandatory for the president to give the assent. There is no other option in the hands of the president. So this is basically what you'll have to understand. So I'm quite sure that the entire constitutional provisions relating to constitutional amendment should be very clear by this time. So what is the article that is giving the power to the parliament? It is Article 368. Under Article 368, all the amendments require special majority plus ratification by half of the state legislatures in some of the cases. Now certain provisions can also be amended by what is called as a simple majority, but if an exception is given in the constitution. But we are not generally referring them as a constitutional amendment. We are referring certain provisions as constitutional amendment only what happens under Article 368 of the constitution. And what is a majority that is required in each cases, what is the option in the hands of the president, and what are the examples for each type of majority has all been discussed. So I'm quite sure that this particular lecture is completely explanatory with regard to the constitutional amendment. And most of the years there's a question that is coming from constitutional amendment in the prelims examination. So please properly listen to this particular lecture. And if you have any questions or any queries, you can reach out to me through my Instagram account or through my Telegram channel. All right. But anyways, before we wind up the session, so just look into this particular question and try to answer this particular question. Which of the following constitute the special majority under Article 368? Majority of total membership of the house, majority of not less than 2/3 of the members present and voting plus absolute majority, majority of more than 2/3 of the total membership present and voting plus absolute majority, none of the above. So you can look into it. So the options can be little confusing. So try to pick out the correct answer. So I'm repeating it again. Between B and C, you can find out majority of not less than 2/3 of the members present and voting plus absolute majority. Majority of more than 2/3 of the members present and voting plus absolute majority. So you can put the answers in the comment box. All right. So for any queries relating to the exam, you can reach out to me through my Instagram or my Telegram channel. And if you like this video, you can also refer this video to your friends and family members who are preparing for the UPSC examination or other competitive examination. And I'm quite sure it is going to be immensely beneficial to all of them. Okay. So thank you very much. Keep watching. All the best.